Hello, everyone, and welcome back to UPC.Insights, the podcast where we unpack the legal developments shaping patent enforcement across Europe. Before we dive in, a quick bit of housekeeping. Starting this month, we're moving from a bi-weekly to a monthly release rhythm. Same format, same analysis, just with a bit more breathing room between episodes to reflect on what really matters. Also, Tilman Pfrang, a recurring guest and UPC aficionado, is currently tracking through the cedar forests and misty peaks of Yakushima, Japan. Tilman, wow. If you're listening, we hope this moss monkeys and matcha are treating you well.
Yeah, George. So far, they do. We have not seen any monkeys so far, but we hope to see some maybe tomorrow or so. That the matcha is perfect. Let me say maybe something to the switch to a monthly release with. We have seen that, I mean, at the first year and in the first year, and maybe also the second year of the UPC, there were a high number of actually very important decisions, landmark decisions sometimes. And now we are seeing that more and more the case law is settling this could have been expected. And so we thought we focus on the really important decisions, such as the one we will discuss later. Really, in my opinion, landmark decision on indirect patent infringement. And yeah, well, therefore, we will slow down a little bit and move to a monthly release rhythm.
Well, that sounds pretty good. I think that's probably right because there's lots going on and we also have lots to decipher in between that time. So now we can bring even a more compact show with more ideas and more thoughts and processes in the value of it. So while some hike, others write, and the judges of the Munich Local Division have been busy, and they're always busy, Tony, you know that. So we're going to start with the BRITA decision. So in today's episode, we'll explore a decision that deserves your attention. On the 22nd of August, 2025, the second panel of the local division, Munich, right here, issued a landmark ruling in the UPC CFI 248/204 concerning EP 2387 and 547B1, a patent held by BRITA SE. BRITA has sued 4 distributors of compatible water filter cartridges for infringement. The defendants, based in Germany, the Czech Republic, Italy, and France, counterclaimed, of course, for revocation. What followed is a technically rigorous and doctrinally rich decision, including 10 headnotes that clarify purpose features, novelty, amendment requirements, and the scope of exhaustion and indirect infringement. Woo, that's a tongue twister. So let's walk through the key takeaways. But first, Tilman, are 10 headnotes a typical number for the UPC decisions?
No, it's not a typical number. It's an extremely high number. I don't recall to have ever seen a UPC decisions with 10 headnotes. On the other hand, I would say, well, it's the case is highly complex, and I think the 10 headnotes is a reasonable number actually for that case.
I can imagine. So then let's start with headnote number 1, the purpose features in a product. What do you think?
Yeah, what I think, let's start what the local division Unix thinks. They think purpose features in a product claim generally define the product in such a way that it must be suitable for the function and purpose stated in a claim. This is not so extremely unexpected from a European perspective, and there have been UPC decisions going in a similar direction. But still, and specifically for our listeners from China or the US, it is again worthwhile repeating that purpose-oriented features in a product claim are interpreted extremely broad. If some container is configured for ink or inkjet printer or something like that, any container which can keep liquid is novelty destroyed. So that's the European way, and now the local division in Munich has, in the first headnote in that case, repeated this.
Well, that's pretty good. So then, in assessing novelty under Article 54 EPC, what do you think?
Yeah. Here, the local division Munich, it follows up on the third headnote actually, and they say if a product claim contains a purpose feature, it is normally only relevant whether the prior art discloses all structural features. A different conclusion applies only if the prior art product is unsuitable for the claim purpose or would need modification to serve it. I mean, it's similar to what I've said before. Let's assume you have a potential novelty destroying container which is made of paper.
Okay.
And the subject matter of the claim of the patent is ink cartridge. Then, of course, you would say a container made of paper is not suitable for containing ink. Only in such a situation, the local division Munich is of the opinion of, and I totally agree with this. Only in such a situation, the prior art container would not be novelty destroying. By the way, this mirrors only the infringement sides. I mean, also paper container could not infringe a patent which is claiming an ink cartridge for inkjet printers.
It seems like a very tricky way to maneuver to either consider it infringement or not to consider it infringement. Yeah.
Yeah, tricky. We can call it tricky. I mean, in the end, it's about also on the very beginning, when you draft the claim and you draft the claim set, you should be aware of this. At least if your target market is Europe, then you should be aware of what it actually means if you claim a cartridge for an inkjet printer instead of an inkjet printer comprising a cartridge. This is a totally different thing. Also in that case, by the way.
Yeah. And then if the patentee defends the patent, what happens then?
This is about, now we're coming to the third head note. There, the local division says if the patentee defends the patent only via auxiliary request, should the granted version fall, then under Article 76, Paragraph 1, UPC agreement, there is no need to test whether a partial revocation under Article 64.3 UPCA would suffice. So 64, Paragraph 3, UPC would suffice. This is very interesting, and I think there is a different decision of central division or local division in Paris, actually. What they say here is, let's assume you have auxiliary request and you normally have auxiliary request. Then the next step after any one of the claims of the main request, usually the patent is granted, is not found valid. The next step is that you move on to the first auxiliary request and then second and third and so on. You do not look whether potentially any other claim of the main request is valid. If one claim isn't, then the main request is not discussed anymore and you move on to the auxiliary request. Only if they're all in the auxiliary request, all claims are valid, then you will, then the patent survives in that form. Otherwise, you move on to the next auxiliary request.
Okay. And then that brings me up to the head note number 4. If a patent has multiple independent claims and auxiliary requests, what do you think?
There they say if a patent has multiple independent claims and the auxiliary requests present only close claim sets, each independent claim must be present in an allowable form for the patent to be maintained. I think they could actually say each claim, not only independent claim, because sometimes, for example, there is an inadmissible amendment of a dependent claim. I don't know whether they have thought about such a situation. More interesting is maybe for non-German listeners what they mean with a closed claim set. This is a terminology we are well aware of in German case law. They mean with this that you present your claim set as a defense in its entirety. So you say, I go to the next step of the proceedings with this claim set. This is a closed claim set. An open claim set would be that you clarify to the court, well, I want to defend each single claim this claim.
Yeah.
So if claim 1 is found not allowable, I want you to move on to claim 2, then claim 3, and so on. This is possible in German practice, and it seems as if it was not done in the present case, but it seems as if the UPC local division in Munich would have allowed such open claim sets.
Do you think this is a precedent that they're setting in the local division in Munich, or is it something that would Dusseldorf or in Paris or wherever?
I wouldn't say it's a precedent, but I find it very interesting that they use this language. I have not read this terminology, even the closed claim set in a UPC decision. What I think I've seen in the Paris decision was that they examined all of the requests and then all of the requests failed. And then they moved on actually with a dependent claims of the main request patent is granted. This was also interesting to see. But they did not examine every dependent claims of the auxiliary requests.
Okay.
and another approach maybe. But here I assume that open plans, that's our code for the UPC local division.
Interesting. So then headnote 5, any amendment must comply with Article 84 EPC.
This is, well, they say that. And as they say further, okay, that means checking whether the amendment introduces any lack of clarity. Good to have this in a head note and a decision. But it's not different to what the enlarged court of appeal of the EPO decided. They come to the same conclusion. This means you can, for example, not attack a feature in a claim which was there before the amendment was added. You can only attack the amendment as such. This is in the head note. It's good to have this now in a head note and a UPC position. So, but nothing surprising, nothing totally new for European practitioners at the least.
Okay. Then headnote 6 under Article 29 UPCA. Exhaustion covers extended stuff. What does that mean?
We move to more infringement-related issues. They say under Article 29 UPC agreement, exhaustion covers intended use of a patented product lawfully put on the market, including standard maintenance and restoration of functionality due to wear or damage. But remanufacture remains reserved to the patent proprietor. This is a very abstract explanation.
Sounds like it. Okay.
Always subject of the particularities of the specific case. Here, again, maybe to come to the ink cartridge analogy. Here, if the invention totally lies in the inkjet printer,
Okay.
all the innovative aspects of the invention lie in the inkjet printer, then probably this head note tells us, well, if a third person does only the ink cartridges, then they would understand it as a maintenance issue or restoration of functionality of the ink cartridge system, including the printer and the ink cartridge. A remanufacture would probably be if actually there is any mention in the ink cartridge, and this is reserved to the patent proprietor.
Note 7, whether replacing a part constitutes use or remanufacture depends on whether the product's identity is preserved. That's kind of where we were going with that, right?
Yeah, exactly. They say that whether replacing a part constitutes use or manufacture depends on whether the product's identity is preserved. And then they say this requires balancing the patentee's interest in economic exploitation against the purchaser's right to use the specific product. So here, this is, I understand, a sub-criterion for head note 6 for the preceding head note. There they give guidance actually on how to proceed in such cases. So it's a balance of interest.
Right.
And you must look into the patentee's interest in the exploitation of its patent. And you must also look into the purchaser's right. This might be, for example, the buyer of an inkjet printer, including an ink cartridge, that those purchaser has a right to use the specific product.
So then that brings me to head note 8. Then if part replacement is standard and expected by customers, what can that offer? What does that tell us?
If a part replacement is standard, they say, and expected by consumers during the product's lifetime, it is typically considered permitted use, unless technical effect of the invention lies in the replaced part. This I meant when I said there is another head note which clarifies a bit more this abstract idea of the previous head note.
Mm-hmm.
In an example I had basically, I think more than 15 years ago. So on my desk, and this was actually an ink cartridge with a so-called signal blocking portion. It was adapted to block a signal from a printer. And all the emission of the signal and the evaluation of the signal, all was done by the printer. And the only function of the cartridge was to block the signal. And in my opinion, this would be exactly something where, as I would say, the technical effect of the invention, it does not lie in the replaced part, does not lie in the cartridge. It lies in the printer where everything's done, signal emission, evaluation.
Oh, that's pretty interesting. So I'll take head note 9. In cases of indirect infringement under Article 26 to UPCA, what does that tell us?
In case of indirect infringement under Article 26 UPC, The local division says if the challenge product has a non-infringing use, any injunction must be limited. Acceptable measures include warnings and or non-use contractual obligations.
So what do you mean by warnings? What could that mean?
Yeah. Again, let's assume we do not have the case where the ink card, which is just there for blocking a signal.
Okay.
And let's assume really a substantial part of the invention is incorporated in the ink cartridge. Maybe a specific valve which is counteracting with valve receiving part of the ink cartridge, of the ink printer. Let's assume such a situation. And let's assume, therefore, they came to the conclusion that there is indirect infringement. And then, for example, any third party selling such ink cartridges which are claimed by the patent could or must actually include a warning on the package of the ink cartridge, so that those ink cartridges are not, they are suitable actually, they have to say, or they cannot be used in printers,
right,
where the whole system is then established. So let's assume you have a patent claim of a ink cartridge or ink printer system,
Mhm.
and the third party can only sell the ink cartridges in isolation if they warn about the following, and namely that they cannot be used with a printer with the features of the claim.
So that kind of reminds me of my Nespresso coffee machine that I have. When I try to avoid buying the true Nespresso coffee machines and I go for the cheaper capsules to go in there, sometimes they do work, but they don't work as good as the manufactured capsules, or they don't have the same flair. But do they have to pay like Nespresso the rights to use that? I mean, to have a concept. You know what I'm saying? It's like there's capsules, there's different markets on the thing, but do they have to initially pay the founder of these capsules to?
It is funny that you're mentioning that because they have quite a number of cases in Germany about exactly these capsules. And similarly, by the way, about the coffee pads. So these are very good examples if you want to illustrate where you are. Are you on the side where you say, well, the whole invention lies actually in the machine, in the spreader machine? If that's the case, then any third party can also sell such replacement capsules. And then obviously you did, so it was allowable, and therefore I assume it was okay, even if Nestle there had their patents on that, of course.
Interesting. Good. Okay. So that brings us to our last head note article at number 10, at Article 64. UPCA does not apply to indirect infringement. What could that mean? What does that tell us?
Article 164 UPC does not apply to indirect infringement, meaning courts cannot issue formal declarations of infringement in such cases. Maybe we should have some comment on what Article 64 UPC actually is about. It's about a list of potential measures the court can order, and one of these measures is just a formal declaration of infringement. It's kind of a positive infringement declaration. More common is a negative or declaratory judgment that there is no infringement, a negative declaration.
Okay.
But also the court can, according to Article 64, decide just formally, well, there is infringement. Article 64 at that stage is not about damage compensation or injunction. It just is about the court declares, well, there was infringement. The Article 64, by the way, also contains some other potential measures, such as recall of products. And so this decision was not about recalling of products, but if I read headnote 10, I would say in case of an indirect infringement, there's also no claim for recalling the products from distribution channels. A number of claims are out of the game, actually, if the case is about an indirect infringement. This is very interesting to see.
So that concludes this month's episode of UPC Insights. Thank you very much, Tilman, coming live from Japan. The BRITA ruling is a powerful reminder of how the Unified Patent Court is actively shaping doctrine, clarifying the treatment of purpose features, novelty standards, and what counts as permissible repair versus remanufacture. Thanks for tuning in. And if you're heading out on vacation like Tillman, the lucky dog, take your headphones and bring the UPC with you. We'll be back next month with more insights from the front lines of the European patent litigation. Don't forget to subscribe, share, and rate the show wherever you listen. You can catch us on previous episodes on preliminary injunctions, inventive step, and procedural convergence between EPO and UPC on all major platforms. Until next time, I'm George Walden with Tilman Pfrang and live from Japan. And this was the UPC Insights. Take care.